I was sitting in my living room when I saw the tow truck hauling my brand new snowmobile off my property. And that's when I knew my quiet life in rural Vermont was about to get a whole lot more complicated. My name is Zachary Rollins, and I had moved to Stowe, Vermont 3 years ago after selling my software company in Boston. I bought a beautiful 50-acre property that bordered the Green Mountain National Forest, complete with a cozy log cabin, a workshop, and most importantly, direct trail access to thousands of acres of pristine backcountry. I had specifically chosen this property because of the private trail that cut through my land, connecting to the main snowmobile trail system. It was paradise for someone like me who lived for winter sports. The HOA of Mountain Vista Estates, the development that had sprung up about a mile from my property 5 years before I moved in, had always been a minor annoyance. Even though my property was not technically part of their development, the president of their HOA, a woman named Geraldine Summers, seemed to think she had jurisdiction over everything within a 5-mile radius. She was the textbook definition of a busybody, always wearing her signature purple fleece jacket and carrying a clipboard like it was a weapon. I grabbed my coat and ran outside into the February cold, my breath forming clouds in the freezing air. The tow truck was already halfway down my driveway, my $10,000 Ski-Doo Renegade strapped to the flatbed. "Hey, stop, that's my property," I shouted, running after the truck. The driver, a young guy who looked uncomfortable with the whole situation, rolled down his window. "Sorry, man, I'm just following orders. Got a call from the Mountain Vista HOA saying this was illegally parked on their trail." "Their trail? This is my land. That snowmobile was parked on my property on my trail." I was furious, my face probably as red as a tomato despite the cold. "Look, I don't want any trouble. You'll have to take it up with the HOA. I'm just the tow guy." He started rolling up his window. "Where are you taking it?" I demanded. "Impound lot on Route 100, Mountain View Storage." With that, he drove off, leaving me standing in my driveway in disbelief. I immediately went back inside and called the number for Mountain Vista HOA. A cheerful voice answered. "Mountain Vista Homeowners Association, this is Deborah speaking." "This is Zachary Rollins. Your HOA just had my snowmobile towed off my own property. I want it returned immediately." "One moment, please." The hold music was some awful synthesized version of classical music that made me want to throw my phone across the room. After what felt like an eternity, a different voice came on. I recognized it immediately. Geraldine Summers. "Mr. Rollins, this is Geraldine Summers, president of Mountain Vista HOA. Your snowmobile was parked on HOA property in violation of our community guidelines." "Geraldine, I don't know what you're talking about. My snowmobile was on my property on my private trail." "I'm not even part of your HOA. Actually, Mr. Rollins, if you had bothered to check the county records, you would know that the trail running through your property is actually a shared easement. While you own the land, the trail access rights belong to the community. Your snowmobile was blocking access, and according to our bylaws, we have the right to remove any obstruction." I took a deep breath, trying to control my anger. "That's complete nonsense. I've checked my property deed extensively. That trail is entirely on my private property. There's no easement." "I suggest you check again. And until you do, your snowmobile will remain in impound. You can retrieve it once you pay the towing fee and the citation fine. That will be $850. You can't be serious." "Deadly serious, Mr. Rollins. Have a nice day." She hung up. I stood there, phone in hand, absolutely seething. This woman had gone too far. I immediately called my lawyer, a sharp woman named Patricia Chen who had handled my property purchase 3 years ago. "Patricia, it's Zach Rollins. I need your help immediately." After explaining the situation, Patricia agreed to pull all the property records and easement documentation. She called me back 2 hours later. "Zach, I've got good news and bad news. The good news is you're absolutely right. There is no easement on your property. That trail is 100% yours, and the HOA has no legal right to it whatsoever. The bad news is that Geraldine Summers has been telling the Mountain Vista residents that there is an easement, and they've been using your trail for years believing they have the right to do so. So she's been lying to them. It appears so. Or she's genuinely confused, but given her position, she should know better. I'm drafting a cease and desist letter right now. I'm also going to contact the impound lot and the towing company. What they did constitutes theft. You should also file a police report." I drove straight to the Stowe Police Department. The officer on duty, a friendly guy named Officer Martinez, took my statement and looked genuinely concerned. "Mr. Rollins, this is pretty cut and dry. If the snowmobile was on your property and you're not part of the HOA, they had no right to have it towed. I'll contact the impound lot and have them release your snowmobile immediately. No charges for you. As for the HOA, you might want to consider pressing charges for theft. I want to talk to them first, but I definitely want this documented. Smart move. Here's your case number. Keep us updated." By the time I got to the impound lot with my truck and trailer, Patricia had already worked her magic. The lot manager, a gruff man in his 60s, apologized profusely. "I'm sorry, Mr. Rollins. We got a call from someone claiming to be from the county saying this was an abandoned vehicle on public property. We should have verified better. No charge for the release." I loaded up my snowmobile, which thankfully appeared undamaged, and headed home. But I wasn't done. Not by a long shot. That evening, I pulled out all my property documents and studied them carefully. The trail that ran through my property was indeed entirely mine. But what made this situation interesting was that this trail was the only convenient access point from Mountain Vista Estates to the main trail system. Sure, residents could drive 20 miles around to another access point, but my trail cut that down to less than a mile of easy riding. For years, apparently, Mountain Vista residents had been using my trail under the false assumption that it was a community easement. I had never really minded because I rarely saw them, and when I did, they were always courteous. But Geraldine had crossed a line. I spent the next morning installing a heavy-duty gate at the point where my trail met my property line, right where it would block access from the Mountain Vista side. It was perfectly legal since it was my property. I also installed several private property no trespassing signs and a game camera to monitor any potential trespassers. My phone rang around noon. It was Patricia. "Zach, I just got a very angry call from Geraldine Summers. Apparently, you've blocked access to what she's still calling the community trail. It's my property, Patricia. I have every right to control access." "Absolutely. I told her as much. She's threatening legal action. I told her to bring it on." She also mentioned something about an emergency board meeting tonight. Apparently, several residents are upset. Let them be upset. They should be upset with Geraldine for lying to them, not with me for exercising my property rights. That evening, I was relaxing with a beer when I heard snowmobiles approaching. I looked out my window to see 3 machines pulled up at my new gate. In the fading light, I could see the riders examining the gate and signs. One of them, I was pretty sure, was Geraldine based on the purple jacket visible even through her snow gear. I decided to go out and talk to them. When I approached, I could hear raised voices. "This is outrageous. He cannot block community access." That was definitely Geraldine. "Geraldine, if this is really his property, he can do whatever he wants." That was a male voice I didn't recognize. "Good evening," I called out as I approached. The three riders turned to face me. Geraldine pulled off her helmet, her face red with anger and cold. "Mr. Rollins, you remove this gate immediately. You are interfering with community access rights." "There are no community access rights, Miss Summers. This is my private property, as I've told you multiple times. You had my snowmobile illegally towed, and now I'm exercising my right to control who uses my land." One of the other riders, a middle-aged man with a thick beard, stepped forward. "Sir, I'm Tom Patterson. I live in Mountain Vista. We were told when we bought our homes that we had easement access to this trail." "Are you saying that's not true?" I actually felt bad for the guy. He seemed genuinely confused and concerned, not angry. "Mr. Patterson, I'm afraid that's exactly what I'm saying. You can verify it with the county recorder's office. There is no easement on my property. Miss Summers has been allowing residents to use my trail without my permission and without any legal right to do so." "That's a lie," Geraldine practically screamed. "I have documentation." "Then I'd love to see it. My lawyer would too." "Because the county has no record of any easement and my property deed is crystal clear." The third rider, a woman probably in her 40s, spoke up. "Geraldine, is this true? Did you actually verify the easement before telling everyone we could use this trail?" "Of course I verified it." "This man is trying to hold the community hostage, Miss Summers. I'm not holding anyone hostage. I'm simply controlling access to my private property, which is my legal right. If you had asked permission nicely, if you hadn't had my property stolen, we wouldn't be in this situation." Tom looked between us, clearly trying to process everything. "Look, if there's been a misunderstanding, maybe we can work something out. We have over 40 families in Mountain Vista who use this trail regularly. Without it, we'd have to drive all the way around through Waterbury to access the main trail system." "I understand that, Mr. Patterson. And until this morning, I never had a problem with residents using the trail. But Miss Summers decided to escalate things by having my $10,000 snowmobile stolen from my own property. She made this personal." Geraldine's face was getting redder by the second. "We did not steal anything. We removed an obstruction from community property. For the last time, it's not community property. And now it's closed. I want you all off my land. Immediately." The woman rider turned to Geraldine. "I think we need to have that emergency board meeting right now. This is a serious problem." They left, and I could hear Geraldine arguing loudly with the other two as they rode away. I went back inside, knowing this was far from over. The next morning, I woke up to find an official-looking letter had been slipped into my mailbox. It was from the Mountain Vista HOA board, signed by Geraldine, demanding that I remove the gate within 48 hours or face legal action for disrupting community access and causing material harm to property values. I forwarded it to Patricia, who called me back laughing. "This is the most ridiculous thing I've ever read. She's threatening to sue you for exercising your property rights. Please, please let her try. I would love to take this to court." "What are my options here, Patricia?" "Well, you can keep the gate up, which is your right. If they trespass, you can have them arrested. If they sue, they'll lose and probably end up owing you legal fees. Or you could negotiate some kind of formal easement agreement, but given how they've treated you, I wouldn't recommend being generous. I want to make a point first. Let's see how they handle the next few days." I didn't have to wait long. That afternoon, I was working in my shop when I heard the sound of chainsaws. I rushed outside to find two men in Mountain Vista HOA vests attempting to cut down trees near my property line to create an alternate path around my gate. "Hey, stop, that's illegal," I shouted. The men looked up, startled. One of them, a younger guy maybe in his 20s, looked guilty. The other, older and with a defiant expression, kept his chainsaw running. "We're on HOA property," the older man shouted back. "No, you're not. You're 15 feet onto my land." I pulled out my phone and called 911. Within 20 minutes, Officer Martinez and another officer arrived. I showed them my property markers and the survey stakes I had wisely installed a year ago for exactly this kind of dispute. The GPS survey app on my phone confirmed we were well within my property boundaries. "Gentlemen, you need to stop immediately. This is private property, and you're committing criminal trespass and vandalism," Officer Martinez said calmly but firmly. The older man finally shut off his chainsaw. "We were told by Geraldine Summers that this was HOA property and we needed to clear an access path." "Do you have documentation showing ownership?" the other officer asked. "Well, no, but Geraldine said." "Geraldine Summers doesn't override property law. Pack up your equipment and leave. Now, Mr. Rollins, do you want to press charges?" I thought about it. These guys were just following orders, probably volunteers trying to help their community. Not against them, but I want this documented for when I do press charges against Geraldine Summers. The officers took statements and photos, issued warnings to the two men, and left. I added more cameras around my property line, including several trail cameras at key points. That evening, my phone rang from an unknown local number. I answered cautiously. "Mr. Rollins, this is Beth Cooper. I'm on the Mountain Vista HOA board, Vice President. I was one of the riders at your gate yesterday." "I remember. Listen, I want to apologize for what's been happening. Several of us on the board had no idea that Geraldine had been operating under false assumptions about the trail easement. We've been doing some digging, and you're absolutely right. There is no easement. I appreciate you looking into it. We're calling an emergency meeting tomorrow night to address this situation. Geraldine is insisting that she's right, but the documentation doesn't support her claims. Would you be willing to attend? I think it would be good for the community to hear your side directly." I considered it. Part of me wanted to just keep them locked out and let them figure it out themselves. But another part of me recognized that most of these people were innocent homeowners who had been misled. "I'll attend, but I want my lawyer present." "Of course. 7 p.m. at the community center. Thank you, Mr. Rollins." The next evening, Patricia and I arrived at the Mountain Vista Community Center to find a packed room. There must have been 60 or 70 people there, and the energy was tense. Geraldine sat at the front table with 4 other board members, her expression sour when she saw me walk in. Beth Cooper called the meeting to order. "Thank you all for coming on such short notice. We're here to discuss the situation with the trail access and Mr. Zachary Rollins' property. I want to start by saying that the board has reviewed all available documentation, and I need to share some difficult news with the community." Geraldine tried to interrupt, but Beth held up her hand. "The trail that runs through Mr. Rollins' property, which we have been using for years, is not actually a community easement. It is entirely on his private property, and we have no legal right to use it." The room erupted in confused and angry voices. Beth waited for them to quiet down. "I know this is shocking. Many of you, like me, purchased your homes with the understanding that we had access to this trail. However, after reviewing the county records and speaking with the county recorder's office, there is no easement registered on Mr. Rollins' property. We have been using his trail without any legal basis. That's because the easement was implied, Geraldine shouted. The trail has been used for decades. Patricia stood up. If I may, I'm Patricia Chen, Mr. Rollins' attorney. An implied easement requires specific legal conditions to be met, including continuous use before the property was divided, necessity, and other factors. None of those conditions apply here. Mr. Rollins purchased his property with clear title 3 years ago. The trail existed, yes, but it was always on private property. Your development is only 5 years old, and the previous owner of Mr. Rollins' property never granted any easement. A man in the back stood up. So what are we supposed to do now? I bought my house specifically because of the trail access. Beth looked uncomfortable. That's something we need to address as a board. If any of you were misled during your home purchases about the trail access, you may have legal recourse, but it would be against the developer or the HOA, not against Mr. Rollins. This is his fault, Geraldine pointed at me. He's the one who put up that gate. I stood up, feeling the weight of dozens of eyes on me. If I may speak, Beth nodded. Please. I understand that many of you are upset and confused. I want to be clear about something. I never had a problem with people using the trail on my property. For 3 years, I saw Mountain Vista residents on that trail regularly. You were always respectful, you didn't litter, you didn't cause problems. I had no issue with it. Then why did you block access? Someone called out. Because Miss Summers had my snowmobile illegally towed from my own property. She claimed I was blocking community access on community property. That was false on every level. My snowmobile was on my land, and it wasn't blocking anything. When I tried to resolve this civilly, she doubled down on her false claims and demanded I pay nearly $1,000 to get my own property back. I could see people looking at Geraldine with new skepticism. I installed the gate to make a point. This is my property. I have rights. If Miss Summers had approached me respectfully, if she had asked for permission or tried to negotiate an actual easement agreement, we wouldn't be here right now. Tom Patterson, the bearded man from the night at the gate, stood up. Mr. Rollins, is there any way we can work this out? I mean, is there any possibility of establishing a proper easement or getting permission to use the trail? Before I could answer, Geraldine slammed her hand on the table. We should not have to beg this man for access to our own community trails. This is extortion. It's not extortion, Patricia said firmly. It's property rights. And Miss Summers, you should know that your actions over the past few days have potentially exposed the HOA to significant liability. You authorized the towing of property from private land. You directed workers to attempt to cut trees on private property, and you've made false claims about easements. Mr. Rollins would be well within his rights to sue the HOA for harassment and theft. The room went silent. Beth Cooper looked directly at Geraldine. Is this true? Did you authorize cutting trees on Mr. Rollins' property? I authorized clearing what I believed to be HOA property to restore community access. But you knew the property boundaries were in dispute. You knew Mr. Rollins had legal representation claiming otherwise. Why would you authorize potentially illegal action without verifying the boundaries first? Geraldine's face was bright red now. Because I've been president of this HOA for 4 years, and I know what's best for this community. We can't let some outsider bully us. I'm not bullying anyone, I said calmly. I'm literally just standing on my own property trying to protect my rights after you had my property stolen. Another board member, a slim man in his 50s, spoke up. I think we need to have a closed session board discussion. This meeting is getting out of hand. Beth agreed. I think that's wise. Mr. Rollins, Miss Chen, would you be willing to meet with just the board members to discuss potential solutions? Patricia and I exchanged glances. She nodded slightly. "Yes, we can do that," I said. The room cleared out over the next 10 minutes with residents giving me mixed looks, some apologetic, others hostile. Finally, it was just me, Patricia, and the 5 board members. Beth started. "Mr. Rollins, I want to be completely honest with you. This HOA is not wealthy. We have about $30,000 in reserves, and most of that is earmarked for road maintenance and snow removal. If you sue us, you'd probably win, but it would bankrupt the association and hurt a lot of innocent homeowners." "I don't want to bankrupt anyone," I said. "I just want respect for my property rights." "Understood. So let me ask directly, what would it take for you to allow continued trail access?" I had been thinking about this since the meeting was announced. First, Geraldine Summers needs to resign from the board. She's proven she can't be trusted to operate in good faith. "Absolutely not," Geraldine shouted. "I've dedicated years to this community." "You've also cost them their trail access and potentially exposed them to lawsuits," Patricia pointed out. "Mr. Rollins is being quite reasonable, actually." The slim board member, who introduced himself as Richard Thornton, nodded slowly. "I've been concerned about some of Geraldine's decisions for a while now. This situation is just the latest example. I would support asking for her resignation." "This is a coup," Geraldine stood up. "You can't force me out." "Actually," Tom Patterson said. He was apparently the treasurer of the board. "According to our bylaws, the board can remove an officer with a 2/3 vote if that officer has acted against the interests of the association. I'd say authorizing illegal tree cutting qualifies." Beth looked pained but determined. "Geraldine, I think it's time. You've been a dedicated president, but this situation has gotten completely out of hand. I'm going to ask for your resignation. If you don't offer it voluntarily, I'll call for a vote." Geraldine looked around the table, seeing no support. "Fine. You're all making a huge mistake. Don't come crying to me when he demands thousands of dollars for trail access." She grabbed her coat and stormed out, slamming the door behind her. The room felt lighter immediately. "Okay," Beth said, taking a deep breath. "That was unpleasant but necessary. Mr. Rollins, you were saying?" "First condition met. Second, I want a formal written apology from the HOA for the towing incident and the tree cutting incident." "Done," Beth said immediately. "Third, I want all costs I've incurred so far covered. That includes my lawyer's fees, my time, and damages. That comes to about $5,000. Patricia leaned over and whispered, "You could ask for more." I shook my head slightly. "That's what's fair." Tom pulled out a calculator and winced. "That's going to hurt our reserves, but we can do it." "What else?" "In exchange for those 3 things, I'll grant the HOA a formal easement for trail access across my property. The easement will be 20 feet wide along the existing trail route. It will be for non-motorized and snowmobile use only. No ATVs during mud season. The HOA will be responsible for basic trail maintenance in the easement area, and they'll carry liability insurance that covers any incidents on the easement. The easement will be recorded with the county, making it official and permanent." Beth looked surprised. "That's actually very generous. I told you, I never had a problem with the trail use itself. I had a problem with being bullied and having my property stolen." Richard spoke up. "There's one more thing we need to address. What about Geraldine? Should we pursue any legal action against her personally for the decisions she made?" Patricia answered. "That's up to the board. However, I'd note that, as president, she was acting in her official capacity, which means the HOA is likely liable for her actions regardless. Pursuing personal action against her would be costly and might not achieve much. But she should face some consequences," Tom said. She lied to all of us about the easement. Her resignation is a consequence, I said. And honestly, I just want to move on. Let's get the easement agreement drafted and recorded, get this resolved and put it behind us. We spent the next hour working out the details. Patricia drafted a rough agreement on her laptop, and we all reviewed it. The board members agreed to have their own lawyer review it and then present it to the full membership at the next regular meeting. As Patricia and I were leaving, Beth walked us out to the parking lot. "Mr. Rollins, thank you for being reasonable about this. A lot of people would have just sued us into oblivion. I'm not interested in ruining people's lives. I just wanted my property rights respected. I understand. And for what it's worth, I'm sorry about how Geraldine handled this. She meant well, I think, but she let her ego get in the way of good judgment. It happens. Make sure that check gets to me within 30 days and have your lawyer send the reviewed easement agreement to Patricia. We'll get this finalized." Over the next 3 weeks, things moved surprisingly smoothly. The HOA hired a real estate attorney who made a few minor modifications to the easement agreement, all of which were reasonable. The full HOA membership voted to approve the easement at their next meeting, with only 3 dissenting votes. The check for $5,000 arrived on day 28. I removed the gate once the easement was officially recorded with Lamoille County. The day after I took it down, I was in my shop when I heard a snowmobile pull up. It was Tom Patterson, Mr. Rollins. "Got a minute?" "Sure, Tom. What's up?" "I just wanted to thank you personally. My family and I love snowmobiling, and we were devastated when the trail closed. I know you could have made this a lot worse for us. No hard feelings. How's the HOA functioning without Geraldine?" Tom laughed. "Actually, a lot better. Beth is doing a great job as president. She's organized, she doesn't let her ego get in the way, and she actually checks facts before making decisions. We should have made the change years ago." "What about Geraldine? How's she taking it?" "Not well. She's been posting angry rants in the community Facebook group about how we all betrayed her. Most people are ignoring her at this point. I heard she's thinking about moving." "That's too bad. I mean, I didn't want to ruin her life." "You didn't ruin anything. She did this to herself. Anyway, I just wanted to say thanks. And if you ever need anything, let me know. I'm a contractor, so if you need any work done on your place, first consultation's free." "I appreciate that, Tom." He rode off, and I felt good about how things had turned out. But I should have known it wouldn't end there. 2 days later, I was woken up at 2 in the morning by a loud crash. I grabbed my phone and checked the security cameras I had installed around my property. Someone had driven a vehicle through my front gate, the one at the entrance to my driveway, not the trail gate which I had removed. I immediately called 911 and then accessed my camera footage. The vehicle was a dark SUV, and while the image was grainy due to the darkness and snow, I could make out what looked like a purple jacket on the driver. Officer Martinez arrived within 20 minutes, along with another officer. "Mr. Rollins, this is the 3rd call we've had from you about this property in a month. What happened now?" I showed them the damaged gate and the footage. Officer Martinez studied the video carefully. "That looks like it could be Geraldine Summers' vehicle. She drives a dark blue Subaru Forester, and that's definitely her signature purple jacket." "So what do?" I asked. "We go have a conversation with Miss Summers. This is criminal mischief at minimum, possibly criminal trespass depending on what she was doing on your property after the gate." The officers headed toward Mountain Vista Estates while I waited at my property. They returned an hour later with news. "Mr. Rollins, we spoke with Miss Summers. She was highly intoxicated and initially denied everything, but when we mentioned we had video footage, she broke down and admitted to it. She's been arrested for DUI, criminal mischief, and criminal trespass. Her vehicle has front-end damage consistent with hitting your gate. Was anyone hurt? No, thankfully. She apparently drove here, crashed through your gate, drove about 100 feet onto your property, realized what she was doing, and then drove home. She's lucky she didn't hit a tree or flip her vehicle. What happens now? She'll be arraigned tomorrow. Given that this is property you own and there's clear video evidence, plus her admission, this is a pretty solid case. You'll need to provide a statement and the video footage. I'd also recommend getting an estimate for the gate repair and filing for restitution. The next morning, I met with Patricia to discuss the situation. This changes things, she said. Geraldine has now committed actual crimes against you and your property. The HOA situation is resolved, but this is personal criminal action. I don't want to destroy her life. Zach, she drove drunk onto your property and destroyed your gate at 2 in the morning. That's not a minor dispute, that's criminal behavior. She needs to face consequences, or she'll never learn. I knew Patricia was right. Later that day, I provided my statement to the police and gave them copies of the security footage. The gate repair estimate came to $1,200. Geraldine's arraignment was the next day. I attended to show the court I was taking this seriously. She looked terrible, hungover and disheveled, nothing like the confident HOA president who had started this whole mess. The judge set bail at $5,000 and scheduled a preliminary hearing for 2 weeks out. Geraldine's lawyer, a tired-looking public defender, entered a not guilty plea despite the overwhelming evidence. Over the next 2 weeks, I received multiple calls from Geraldine's family members and friends, begging me to drop the charges. Her daughter, a woman in her 30s named Jennifer, came to my house in person. "Mr. Rollins, please. My mother has had a complete breakdown. She's seeing a therapist now, she's in AA, she's getting help. Pressing charges will destroy what's left of her life." "Jennifer, I'm sympathetic to your mother's situation, but she drove drunk and vandalized my property. What if there had been someone on the road when she was driving drunk? What if she had hit someone? I know. And she knows that too. She's terrified and ashamed. Is there anything she can do to make this right?" I thought about it. "Have her lawyer contact my lawyer. If your mother is willing to plead guilty, accept full responsibility, pay for all damages plus my legal fees, and commit to continued treatment for her alcohol issues, I'd be willing to recommend a lenient sentence to the court. But she has to own what she did." Jennifer nodded, tears in her eyes. "Thank you, I'll tell her." 3 days later, Patricia called me. "I just heard from Geraldine's lawyer. She's willing to plead guilty to all charges. She's offering to pay $1,500 in restitution to cover your gate and fees, and she's already enrolled in an intensive outpatient substance abuse program. Her lawyer is asking if you'd be willing to provide a victim impact statement that recommends probation rather than jail time. What do you think? I think she's getting off easy, but I also think jail time would just make things worse. She's lost her position in the community. She's facing DUI charges. Her reputation is destroyed. Sometimes that's punishment enough." At the sentencing hearing 4 weeks later, I stood before the judge and gave my statement. "Your Honor, Miss Summers' actions against me and my property were serious and wrong. However, I believe she's genuinely trying to get help and make amends. She's paid full restitution, she's in treatment, and she's accepted responsibility. I don't believe jail time would serve justice better than supervised probation and continued treatment." The judge, a stern woman in her 60s, looked at Geraldine. "Miss Summers, you're very lucky that Mr. Rollins is a forgiving man. I'm sentencing you to 2 years probation, 100 hours of community service, mandatory substance abuse treatment, and suspension of your driver's license for 6 months. You will also have no contact with Mr. Rollins or his property. You understand? Yes, Your Honor, Geraldine said quietly. As we left the courthouse, Geraldine approached me, her lawyer and Patricia both looking nervous. Mr. Rollins, I just want to say I'm sorry for everything. I let my pride and my ego turn a simple situation into a nightmare. I was wrong about the easement. I was wrong to have your snowmobile towed. And I was especially wrong to drive drunk and damage your property. I'm getting help, and I'm going to do better. I looked at this broken woman in front of me and felt more pity than anger. I accept your apology, Geraldine. I hope you get the help you need. But please, stay away from my property and let me live in peace. I will, I promise. That was 3 months ago. Spring has arrived in Vermont. The snow has melted, and life has returned to normal. The easement is working well, and I've actually become friendly with several Mountain Vista residents. Tom Patterson and I go fishing together occasionally. Beth Cooper has turned out to be an excellent HOA president, running the association with competence and actual regard for facts and law. I heard through the grapevine that Geraldine completed her community service at a local food bank and has maintained her sobriety. She's apparently moved to Burlington to live with her daughter and start fresh, away from the community where she caused so much chaos. My gate has been repaired and reinforced. I added better security cameras and lighting around my property, not because I'm expecting more trouble, but because I learned my lesson about documentation and evidence. The snowmobile that started this whole mess sits in my garage, waiting for next winter. I've already planned several trips into the backcountry once the snow returns. And yes, I'll be using my private trail, the one I fought so hard to protect, to access those adventures. Looking back, I realize this whole situation taught me several important lessons. First, always know your property rights and have documentation to back them up. Second, stand your ground when you're right, but be willing to compromise when it makes sense. Third, sometimes the best revenge is simply protecting what's yours and letting karma handle the rest. The HOA that tried to tow my snowmobile and claim my land learned a hard lesson about property rights and the importance of verifying claims before taking action. The community that thought they had easement rights learned to check their facts and not blindly trust their leadership. And Geraldine Summers learned that ego and stubbornness can destroy everything you've built if you let them control your decisions. As for me, I learned that sometimes standing up for yourself brings unexpected friendships and community connections. The residents of Mountain Vista, who once saw me as an outsider, now see me as someone who was willing to fight for what was right, but also willing to be fair when things got resolved. I also learned that home ownership in a rural area comes with unique challenges, especially when developments spring up near your property. The key is to be firm about your rights while remaining open to reasonable solutions. I could have kept the trail closed permanently, which was my legal right, but that would have punished innocent people for one person's mistakes. The easement agreement I negotiated gave everyone what they needed. The community got their trail access back, and I got formal legal protection and compensation for the harm done to me. The legal system worked exactly as it should in this case. When the HOA overstepped, the law protected my property rights. When Geraldine committed crimes, she faced consequences but also had the opportunity for rehabilitation rather than pure punishment. When disputes arose, lawyers and courts provided a framework for resolution. I think about what would have happened if I had just let the snowmobile towing slide. if I had paid the impound fees and accepted Geraldine's false claims about easements. I would have set a precedent that anyone could walk over my rights without consequence. The trail access would have continued without any formal legal protection, leaving me vulnerable to future claims and liability. And Geraldine would have continued making decisions based on assumptions and ego rather than facts and law, potentially causing even worse problems down the road. Sometimes conflict is necessary, not because you want to fight, but because you need to establish boundaries and protect what's yours. The key is to fight smart, fight fair, and know when to extend an olive branch once you've made your point. My 50 acres in Vermont remain my sanctuary. The log cabin I call home is still my favorite place on earth. The workshop where I pursue my hobbies stands ready for my next project. And the trail that caused so much trouble now serves its purpose, connecting my property to thousands of acres of beautiful backcountry, accessible to both me and my neighbors through a legal, formal agreement that protects everyone's interests. Next winter, when the snow falls deep and the temperatures drop, I'll fire up my Ski-Doo Renegade and head out onto that trail. I'll probably pass Mountain Vista residents doing the same. We'll wave to each other as we pass, neighbors sharing access to the winter wonderland that makes Vermont so special. And I'll remember the whole crazy saga that started with an HOA president who thought she had more authority than she did, continued through gate installations and police reports and court hearings, and ended with justice served and relationships healed. The gate to my property now bears a simple sign: private property authorized trail access by easement only. It's not unfriendly, but it's clear. It sets boundaries while acknowledging the shared use that makes sense for everyone. In the end, this whole experience reinforced something I've always believed. Property rights matter. The law exists for a reason, and standing up for yourself doesn't mean you can't also be a good neighbor. You just have to find the balance between protecting what's yours and being part of a community. The HOA that tried to tow my snowmobile learned they couldn't bully someone who knew his rights and was willing to fight for them. The community learned that easements and property rights are real legal matters that can't be assumed or invented. And I learned that sometimes the best way to be a good neighbor is to establish clear, legal boundaries that protect everyone. As I sit here now, enjoying my morning coffee and looking out at my property, I feel satisfied with how everything turned out. My rights were protected, justice was served, a reasonable compromise was reached, and even the person who caused all the trouble got a chance at redemption rather than pure destruction. That's the way things should work in a civilized society. Not everyone gets everything they want, but everyone gets what's fair. Mistakes have consequences, but those consequences should match the severity of the mistake and allow for rehabilitation when possible. And neighbors, even when they conflict, should ultimately be able to find common ground that serves everyone's interests. The snowmobile trail through my Vermont property stands as a testament to all of this. It's my land, protected by law and recorded deed. But it's also a shared resource, made accessible through legal agreement and mutual respect. It serves both my interests and those of my neighbors, not because anyone demanded it or stole it or assumed it, but because we all sat down, acknowledged the facts, and worked out a solution that made sense. That's the real ending to this story. Not perfect harmony, because conflict revealed real problems that needed addressing, but resolution, fairness, and the restoration of peace. My snowmobile sits ready for next season, my property remains secure and mine, and the trail that caused so much trouble now functions as it should. A path through beautiful country, legally protected, properly maintained, and enjoyed by people who respect both the land and each other's rights. Sometimes you have to close a gate before people realize it was a privilege to pass through. Sometimes you have to stand firm before others learn to respect your boundaries. And sometimes the best outcome isn't total victory or complete surrender, but a middle ground where everyone gives a little, and everyone gains something valuable in return. That's what I achieved in my battle with the Mountain Vista HOA. I protected my rights, I got justice for the wrongs done to me, I held people accountable for their actions, and then I offered a path forward that served everyone's legitimate interests. The trail is open now, but it's open on terms that are legal, fair, and sustainable for the long term. As for Geraldine Summers, I genuinely hope she's doing well in Burlington. I hope she's maintaining her sobriety, rebuilding her life, and learning from her mistakes. I don't hate her or wish her ill. She made serious errors in judgment that could have been much worse, but she's facing the consequences and apparently trying to do better. That's all anyone can ask. The Mountain Vista community continues to thrive under new leadership. The trail gets regular use and maintenance. My relationship with my neighbors has actually improved through this process, and my daily life has returned to the peaceful, private existence I moved to Vermont to enjoy. Every story needs an ending, and this one ends where it should, with boundaries established, rights protected, justice served, and a community that learned important lessons about the difference between what you assume and what you can actually prove. The HOA that tried to tow my snowmobile ended up with a new president, a legal easement agreement, and a much clearer understanding of property law. And I ended up with exactly what I wanted from the beginning: respect for my rights and peace on my own land.